Right, good afternoon, everyone. Welcome to today's webinar. We're excited to have you with us today. It's noon here in Cape Town, where we're based, and once again, we've got an engaging and timely session lined up for you today. This webinar is proudly brought to you by Real Estate Investor, and I'm Neil Peterson. I'm the founder of REI, South Africa's leading independent real estate platform for real estate news, investing and education since 2007. I'll be your host and moderator today as we explore a topic with significant relevance and potential impact on businesses and individuals across South Africa: private property rights. And at REI, we're dedicated to empowering investors, property and business professionals through our digital platform, rei.co.za, our award-winning monthly magazine, Real Estate Investor, and our regular live webinars and events. And today we're taking that commitment even further. So before we jump into today's session, here's a little bit of housekeeping, recordings, and we get this question a lot. If you've registered for today's webinar, you will send you a link to the recording after the event, and you can also find the recording on our website, on our homepage, rei.co.za, or under the events and webinar section. Questions, we encourage you to engage today. Please submit your questions at any time during the session using the Q&A box that's located on the bottom right-hand side of your screen. We'll make sure to answer as many of your questions as we can at the end of the webinar, which I'm sure there'll be, because we've already got a whole bunch of pre-questions as well. Now, let's get on today's webinar theme: South Africa's Land and Expropriation Act and their economic, social, and property market implications. And today we're going to unpack the impact of that. And we saw that President Cyril Ramaphosa has signed into law the Expropriation Bill on the 23rd of January 2025, which repeals the pre-democratic Expropriation Act of 1975 and sets out how organs of state may expropriate land in the public interest for various varied reasons. And the act has ignited widespread debate around its potential economic impact, the future of land reform, and the ripple effects on the South African property market. So key questions to be addressed today include: what are the significant changes introduced by the Act? How might the Act impact property owners, investors, and land claimants? And is the Act aligned with the original goals of land reform in South Africa? And what safeguards exist for informal landholders? And is there a risk of expropriation without compensation? Plus, we'll be unpacking the property market implication. So, without further ado, we're thrilled to have our three esteemed panelists today who will provide deep insights in today's topic. First, I'd like to introduce you to Simon Dippenaar. He's an attorney of the High Court. Simon, thank you for being with us today. Could you please introduce yourself to the audience?
Thanks, Neil, for having me back. I think the last time we were on was during COVID, so that was also a very interesting time. Things are a little bit different now, but still very interesting and borderline dramatic. So I'm Simon Dippenaar. I'm a founder of a firm called SD Law, or Simon Dippenaar Associates, here in Cape Town. I come from an angle of evictions. We specialize in evictions, residential evictions across the country. And I'm mostly interested to try and determine how these expropriations will take place in a just and equitable way, and our courts will interpret that. But I'm looking forward to the debate. Thank you.
Wonderful. Great having you here, Simon. Next, we have Robert Krautkramer. He's also an attorney. He's a renowned expert on this topic. Robert, thank you for joining us. Please take a moment to introduce yourself to the audience.
Thanks, I appreciate the opportunity. Good morning or good afternoon, rather, everybody. My name is Robert Krautkramer from Miltons, Matsemela attorneys out here in Cape Town, more particularly Tableview and surrounds. I've got a vested interest in this topic because since it's 2019 when the bill was first published, I've been following it quite closely and done quite a few talks on the topic. And I'm very interested to see how this is going to unfold. And my biggest hope and dream is to try and quash a few of those fears out there, thinking that this is all going to result in overnight land grabs left and right, which I think is a bit of a social media hoax. So I'm hoping to be able to address that today. Thanks again, Neil.
No, it's good to hear we're not turning into Zimbabwe, Robert. That's fantastic. Okay, and last but not least, we're pleased to have Martin van Staden of the Free Market Foundation. Martin, thank you for being part of today's discussion. Would you like to introduce yourself to the audience?
Yeah, thanks, Neil. Just on Robert's comment, yet, you forgot to add yet there at the end, Robert, on us turning into Zimbabwe. But yes, I am Martin van Staden. I am the head of policy at the Free Market Foundation. I'm not a practicing attorney or a practicing advocate, but I do have a master's degree in law, and I have been from a public policy and constitutional policy perspective involved with the debate around EWC since at least 2017, December of that year, when the ANC decided to amend the constitution and then went through that whole process. And now we have a normal piece of legislation, the Expropriation Act. So the Free Market Foundation takes a very deep public policy interest in security of private property rights and individual liberty more generally, and limited government. And we believe those things are necessary for a successful and flourishing economy, certainly for investment. But that will inform the perspective from which I engage today. Thank you, Neil, for the opportunity.
Absolute pleasure. Great having you here, Martin. And thank you to all of our panelists, I think, for those introductions. It's a privilege. It really is a privilege to have you today. So let's get into the Q&A, Simon. Given your legal background, what do you think the key implications of the Expropriation Act are for property rights in South Africa? I mean, what key changes does the Expropriation Act bring to the existing land reform process in South Africa, and how does it address the constitutional promise of land reform?
Good question. So, in South Africa, we have the rights to own private property. Private owners can own land. That's codified in our constitution, section 25. It's the hallmark of being able to accumulate wealth. It's something that is very important, I think, in a capitalistic society. It's called what we call in law a real right to be able to use and enjoy your property. However, we do live in a country where we have had a controversial, checkered past, where there has been, unfortunately, a lot of social and racial injustices that have taken place in terms of our legal policies. And there was a commitment in 1994 to recognize and respect that there is a need for some reform, some redistribution to address those racial and social injustices of the past. So our government, in its wisdom, have come up with the Expropriation Act as it is now. It was the bill for about 9 or 10 years or so. So the Expropriation Act is supposed to provide a legal framework in which to justly and equitably reform, commits to achieve the goal of land reform. Rather, it has to be done in the public interest. It has to be done for a public purpose. It has to be equitable. It has to be fair. So in that way, government is trying to create this set of rules, checks and balances in order to achieve that purpose. Now, the problem becomes, do we trust government to be able to implement and execute this in a fair way? So there are some checks and balances that have been put in place. We must also appreciate the context. We did have an Expropriation Act of 1975, except this one that comes into play gives more detail about what is just and equitable, and also a little bit more detail about nil compensation.
Okay, wonderful. I think that's a good way of sort of getting into the topic and getting into the start. So I'm going to bring in Martin now. Martin, as a representative of the Free Market Foundation, what are your thoughts on how this act aligns with the principle of a free market and the protection of private property? And how do you define just and equitable compensation? And how does the act provide clarity on when nil compensation might be applied?
Yeah, thanks, Neil. So I think it's important to start with, yes, the Constitution does require land reform. And I think anyone who takes property rights as a kind of a moral imperative seriously understands that when someone has taken something from you, you must get it back. And the Constitution recognizes that reality. It's restitution. Reivindicatio is an old Roman law principle that kind of transcends political dispensations. So the Constitution does recognize the need for land reform. And the Constitution at the same time protects private property rights. And there are some people in our politics who think that this is a tension in our Constitution or a contradiction even in our Constitution, which is simply, as I said, not the case. You can do both. There are ways to do both in a way that does not harm investor sentiment, that does not harm the interests of property owners. And long story short, the way you do that is when you do, as government, expropriate property for a public purpose. And I don't actually think it's that important what that public purpose is. It is important, but it could be anything. The key thing is you need to pay the owner compensation. South Africa, that standard is called just and equitable. Lots of people want to read things into that. I don't know why, but for me, at least, it's clear that since we're interpreting a Bill of Rights, a just and equitable standard as far as property owners, the persons whose rights are being protected, must start at market value. You have to start at market value of the property, and then you should probably go up. You must probably go up, not down. The idea has been that the other factors listed in the Constitution must bring you down from market value, which to me seems to be a very counter-constitutional way of reading a Bill of Rights. But yes, ultimately, the new act does not really help us in that regard. It does create this impression of going down from market value, and not just going down from market value, but going down all the way to nothing, to zero, to without compensation. And that is the very controversial aspect about no compensation. It's an open list. It provides some examples of when the state may apparently engage in expropriation without compensation. The shorthand word for that is confiscation of property. But it's an open list. And that means the state, whenever it deems it for whatever good reason to be in the public interest, to take someone's private property, fixed property, without paying anything, it could do that, subject to judicial review, etc. But that's not all. The other thing as well is that in terms of the old act, the 1975 Act, quite rightly, there was provision for what is called solatium. It's a very small amount of money, but it's very much a symbolic gesture that recognizes that when the state expropriates property, it does not do so to punish you. An owner whose property is being expropriated has not been found guilty in terms of criminal law, in terms of delict, he has not done anything wrong. So expropriation law is not a tool of punishment or retribution, and solatium is a way of the state saying, here's an additional amount of compensation over and above your market value, for which we are saying, we apologize for inflicting this burden upon you. That's in terms of the old act. The new act has no solatium, and that's part of the Free Market Foundation's broader concern with the act, and that is that this is not a standard piece of expropriation legislation, which you would expect to find amongst the countries of the world that are prosperous and that respect the liberties and property of their citizens. This is very much, let me just kind of qualify, this is not something to go crazy about and panic about, but still, this law does represent the political agenda of a government that is not friendly to private property rights. And that is something at least to be concerned about, certainly not to panic about, but certainly to be concerned about.
Okay, thanks for that, Martin. I think you set that scene very nicely there. So, Robert, I want to bring you in here from your perspective as a legal expert on this issue. How do you see this legislation impacting both businesses and individual in practical terms? I mean, what are the practical implications of expropriation without compensation for property owners, particularly those in the private sector?
Thanks, Neil. The first thing I want to comment on, Neil, is both Martin and Simon have been talking about the old Expropriation Act. And one thing I just want to clarify quickly is we must remember that the old Expropriation Act, or the 1975 Act, is still very much in force. It hasn't yet, it's been replaced by the new Act, but remember, the new Act has not yet commenced. So I think that's an important point at this point in time. So the current 75 legislation is still a valid legislation. And in terms of that legislation, compensation is primarily determined by what a willing buyer and a willing seller would negotiate as a purchase price. And that now records itself as the reasonable market value. So that is currently what the situation is and still remains. So until the Expropriation Act actually commences, at this point in time, there's no fear factor whatsoever. Once it does commence, then I do to some degree also agree with what Martin says. We have to now rely on government. But in addition to that, we also have to remember one thing is that we have this thing called the Constitution, which very much guarantees the right that you may not be expropriated without compensation. But in addition to this, what we have to bear in mind is that every constitutional right is subject to limitation. There's no such thing as an absolute human right, even the right to life. I mean, if you were to miraculously jump out of your screen and come at me with guns blazing, and I have a weapon on me, I'm allowed to kill you in self-defense. So your right to life would be second to mine. So even the right to life is not absolute. So the first thing we have to bear in mind, like I say, is we all have this constitutional right. Secondly, this piece of legislation has to still pass constitutional muster. When it does commence, I'm pretty sure it's going to be taken to the Constitutional Court in a heartbeat. That will happen. It's going to be, I think, a very long process before we start seeing this act being enforced to the degree that it can render any kind of concern for private property owners. We also have what we call administrative justice in South Africa. We have sections 34 and section 33 and 34 of the Constitution, which clearly guarantees us the right to administratively fair judicial review. So any decision taken by any administrative body or by a court for that matter, you're allowed to take it either on review or you're allowed to take it on appeal. So, if I have to answer your question, the reality is that the Constitution already says to us that there's no such thing as an absolute human right, because in the Constitution, it specifically says that as long as, if government wants to limit any of our rights, as long as it is just and equitable, and it is acceptable in a free society or democracy, it can be limited. So what the Constitution actually has been saying to us from the day that it was born in 1996, when we had our final draft, since then already, it would have been possible to expropriate without compensation. The only difference between then and now is that the 1975 Expropriation Act didn't specifically or expressly say so. It only provides for expropriation with compensation dependent on what the reasonable market value of the property might be. The new piece of legislation now takes it a step further and basically crystallizes what the Constitution has been saying, which is that even though the Constitution says you may not be expropriated without compensation, well, technically you can, because the Constitution does say that any human right may even face certain limitations. And all that this piece of legislation does is it creates a mechanism. It tells us when and how and under what circumstances is it possible that government may now be able to expropriate one without compensation. So to answer your question, like I say, I think there's still many, many bridges to cross, and there's still a lot of water to flow under this bridge before we actually start seeing this act being implemented. And when it does get implemented, there is going to be a lot of litigation. There's absolutely no doubt about it. Whether the Constitutional Court's going to agree with us or not, that remains to be seen. So I do think that, as I said from the get-go when I spoke the first time, there's been a lot of panic in the marketplace, and a lot of concern about land grabs and this sort of thing. This piece of legislation does not justify land grabs. There's nothing in this piece of legislation at all which allows it. I do think to a large extent, in finishing my answer to your question, we have to trust the institution. Our constitutional court and our constitution are held in extremely high respect worldwide. The academics out there, there's other judicials or benches, courts internationally have acclaimed the South African Constitution and our Constitutional Court judgments as being some of the finest legal work out there. So we have to trust in that. We really have to trust in that we've got 11 constitutional judges at any given time, and we have to believe in their integrity, that they will uphold the constitutional values as enshrined in the Constitution. And as long as we believe in that, I don't think we have anything to worry about.
Well, that's good
news. Can I jump in there, Neil?
Yes, of course you can.
Okay. I think Martin and Robert raised interesting points. My concern is the definition of public interest and how do we work out what is just and equitable. And the broad definition of public interest may or may not be abused or taken advantage of by some state actors. So perhaps maybe that's something we could debate ever so briefly. The whole concept of justice and equity, or what's fair and equitable, is also a controversial topic. I've seen how those type of cases have been litigated in the context of evictions. Of course, like a landowner has a right to use and enjoy his property. He has to follow an eviction process to evict an unlawful tenant from his property, and it has to be just and equitable. But he has to follow a long court process in order to prove what's just and equitable. One has to look at the individual circumstances of each case, the personal circumstances of the applicant and the respondent, and it can take months, if not sometimes years, to eventually reach a court case. And that's even if the matter isn't appealed. So my concern is that even though there is some judicial oversight to try and interpret what is in the public interest, what public purpose actually should mean, what is just and equitable, whether it is rational, whether it is reasonable, whether it's a law of general application, promoting or applying all the provisions of PAJA as an example, ensuring constitutional compliance, it just means that there may actually be a long, drawn-out court battle that may be necessary to bring certainty and clarity and stability under the circumstances. And as I was joking in our preparation seminar, I was saying that, the courts are very much like the entrance to the Ritz. It's open to everybody, but you can only stay for as long as you can afford. I think Robert had a rebuttal there.
I may exercise that now. I may just add to what Simon says, and I totally understand, because I used to run litigation for many, many years, and he's completely right. In the case of evictions, the landlord is the one that has to evict the tenant. And our experience, and Simon, I'm sure you're going to agree with me here, is that the courts will always jealously guard the tenant's rights, or rather, they will do everything in their power to stop a tenant from being thrown out on street, because we have a right to accommodation in terms of the Constitution. So it's a very difficult, I think, thing for any judge to have to say, all right, madam or sir, you and your child or your aged mother are not going to be evicted here. You're going to be thrown out onto the street. That's a difficult thing to do. And I do understand that for the courts, it must be incredibly difficult to weigh up what is fair, what is just. And we all know, and again, Simon will back me here, a normal eviction these days, just if it's remotely opposed, can easily take upward of 11 or 12 months. And in the meantime, they don't pay their rent. The landlord has to pay tens, if not hundreds of thousands of rands to get rid of the tenant. And by the time the tenant is out, the house has been ransacked, the place is in ruin. The landlord is down hundreds of thousands of rands in lost rental income and legal fees, etc. But here's the shiny part of today's discussion when it comes to expropriation. The Section 19 of the Expropriation Act very clearly states that if the parties cannot agree on a sum of compensation, which would include no compensation, then the landowner may ask for the matter to be referred to mediation. If they can't mediate, the landowner may then say to the expropriating authority, well, sorry, I'm not prepared to accept your zero compensation. I want you to take it to court. So unlike with evictions, where it is the landlord's duty to bear the onus of proof, or to prove that the eviction is fair and just, in this case now it will be government. Government will have to prove that an eviction without compensation is fair and equitable. So the almost positive thing I want to put out here is that the landowner is the one now who can delay this litigation. And yes, it costs money, we all know this. But I also do think that when this legislation does finally kick in, I think there'll be lots and lots of attorneys out there who are going to be more than happy to say, pick me, I'll run this case for you. Run it pro bono or pro amico, whatever they want to do, or they run it on a contingency fee basis. But I really don't think that we're ever going to find landowners who do have a just, what's the reason for opposing a request or a proposal to expropriate without compensation. There's going to be many attorneys who are going to be prepared to assist without charge or to run the matter on a risk basis when it comes to costs. I really do think so. Like I say, one can definitely draw some lines of comparison between evictions and any other litigation. But I do think for that reason, in a case like this, there's a major difference because government has to bear the onus of proof, and government's going to have to push this thing forward. And just as the last point, if government's going to go on a rampage here, it's going to cost them billions in legal fees to address all these issues. And they're going to be up against many mountains, not one, not two, many. And the question is, does government have the capacity to run so many court cases and to push so many of these things? So they also have limitations. They don't have an endless stream of cash either, or an endless stream of resources. So I don't think it's going to be that easy for government to abuse this piece of legislation as some people might think it is. I don't think so.
No,
and the procedures, yeah, go ahead, Martin.
Yeah, I just want to make a kind of just a brief note here, and I think I agree basically with everything that Simon and Robert have said about kind of there are capacity constraints on the state, there are legal processes to go through. But for me and the FMF more broadly, the concern is that you do have to strive as a society to have good law, and kind of resting assured at the idea that the courts will ultimately kind of come to the right answer is a reassurance, but that isn't the whole story. You do want your expropriation law ultimately to be of that nature that it doesn't mean that you as a property owner, or certainly you as an investor, a foreign investor who knows nothing about kind of how South African courts work, and you're now deciding, do I invest in South Africa or do I invest in Switzerland? If you hear that, well, potentially my property can be taken without compensation, yes, I can go to court, but ultimately I don't really want to go to court and play those games. You really want your law to be pretty good basically before you get there, and this act isn't that. I mean, if you look at property rights respecting jurisdictions around the world, like the United States, not perfect, but sometimes you see a highway going and then it has to veer quickly to the side, and then there's a little house, and then it goes back into the straight line it was following. That is an example of where either there was litigation, yes, or the government simply knows, listen, the law is not on our side, and we just have to kind of accommodate the owner in whatever we're doing. And that is the right approach. You have to accommodate the liberties and the rights of your legal subjects, and certainly fulfill your constitutional obligation for land reform. which again you can do in a way that is not this. So yeah, I just think that most South Africans certainly cannot afford to go to court. Even relatively wealthy South Africans cannot generally afford to go to court. So you have to then rely on the pro bono or pro amico kind of generosity of lawyers. And I mean, let's say the quiet part out loud. In many cases, there are going to be very unpopular instances of potentially a farmer being expropriated, with a lot of rhetoric around whether this is social justice or whether this is kind of rectifying the injustices of the past. And I think it's fair to say that many lawyers will feel somewhat uncomfortable to be seen on the side of the rich exploitative landowner against the democratic government trying to enforce its sense of justice. I'm sure there will be a lawyer who will put his hand up, but you don't want to gamble with people's rights like this. But that's not me saying that the courts are going to be unreasonable. I think generally our courts will be good. There will have to be the jurisprudence will have to develop also on a case-by-case basis. If someone is expropriated for nil compensation, so-called, or for less than market value compensation, the courts are probably going to develop certain principles and safeguards in the jurisprudence that will in time become useful. But as we stand now, we almost have a kind of a tabula rasa of new expropriation law, and now there's a lot of uncertainty in the air, and I think people are rightly at least a little bit concerned about where this could go.
Did you want to add to that, Simon?
Well, I was going to maybe say something tongue-in-cheek. The EFF don't seem to be too happy with the current version of the Expropriation Act. I don't know if that's a good or a bad thing for your viewers.
Yeah. No, but, absolutely.
Obviously, there are different political parties that have weighed in on this. Obviously, the DA are also taking this to court. They feel like the act is somewhat ambiguous in its application. There is ambiguity or uncertainty around how to work out what's just and equitable, or rather what is fair compensation under the circumstances. There's some also uncertainty when it comes to the procedure of mediating or resolving disputes. Do you mediate first? Do you take it to court first? Do you do both of those kind of in parallel? So I believe it was Section 7, 8, and 19 of the Expropriation Act that they are currently challenging on the basis of advice that they've received from legal experts. So it may not even come to fruition. We may not even reach a point where this act is actually enforced. But it's drummed up a lot of fear, locally and also internationally. And that hasn't been helped by the rhetoric from the new president of the United States and also Mr. Elon Musk. So they've openly criticized the South African government, I think possibly also to justify withdrawing some aid from it, but I'm not going to get into a political discussion. But they've also caused a lot of fear and apprehension, I think, in the hearts and minds of private property owners and also investors. And that can also be quite counterproductive. So we don't really want people to stop investing their money into South Africa and to reach a point where they don't feel like they can fairly use and enjoy their property. So we have some strong opposition from the DA. We've got the opposition from the Freedom Front Plus. They say that it's an overreach. I've got opposition from Solidarity. COSATU says that it's a fair way to, buy property without inflating the prices. The EFF says it's a legislative cop-out. So diversity of opinion, I think, is also healthy in a constitutional democracy. But I do think that one needs to avoid this fundamental black and white doom and gloom interpretation of the act, specifically because the safeguards are, it must be done for public interest, for the public interest. That needs to be weighed fairly against the interest of the private property owner. Compensation must be just and equitable. And you can only expropriate for nil compensation under very limited circumstances. Abandoned land that's not being actively used, land that's owned by the states that's not going to be used for any future purpose. It can't be done. Land that is being used for developmental and or commercial purposes can't be expropriated for nil compensation. That's excluded. And there's some other ones where there's been a state investment or state subsidy less than or equal to the value of the property. So under those very limited circumstances, land can be expropriated for zero compensation. And I guess the benefit may be that land can then be taken to be used for a good social purpose. One can perhaps earmark it for a social housing project or develop it into agricultural land that can boost smaller, struggling economies. But there's the theory, and there's also the execution.
Absolutely. And I think part of one organization that is part of the solution is certainly the Free Market Foundation with their Kyle Land Project, which I think is a fantastic initiative in terms of the number of titles they have given to people through various donors and very wealthy donors in South Africa. So I want to bring in you here, Martin, in terms of the Act. How does the Act handle the rights of informal landowners? And, what protections, if any, exist for them under the new law? Because, and I would assume that some of the owners of the land that have now been granted title will fall into sort of that category, right or wrong? Your comments?
Yeah, so that's kind of been one of our big worries. And I mean, I just alluded to it a moment ago about how can you afford to fight the overwhelming power of the state, even if you're a relatively wealthy South African, but certainly not if you're a recent beneficiary of a title deed through something like our KLM program. I have to preface that I do not think that probably even under some of the worst circumstances under which this law is applied, imagine Robert Mugabe, imagine Hugo Chavez, imagine Fidel Castro, the chances of people's houses being expropriated is almost zero. It's basically nil. So I don't think anyone really should worry about that. In theory, you can have your house expropriated. You can, if you're a residential owner, you can have your house expropriated for nil compensation. We must remember that land in South Africa refers to what is also on the land. It's the Roman law principle of accession. What is on the land is part of the land. So usually in expropriation cases, there might be separate kind of compensation for the improvements on the land. But ultimately, if you own land and you have something on that land, it could also be expropriated for nil compensation. I don't think that will happen. I think the people who need to be concerned really about their property being taken would tend to be, I would say, large property owners, especially large agricultural owners, but also those people who I would say feel that the adoption of the 2015 Protection of Investment Act was targeted at them. So these would tend to be foreign investors. That act was introduced and essentially repealed South Africa's bilateral investment treaties with various countries around the world, which provided special protection for the property of foreign owners, foreign businesses in South Africa. And those bilateral treaties basically said you must be paid market-based compensation, and this is how it's done. This is the mediation process. The Protection of Investment Act, which is really an attack on Investment Act, just so we can be clear about that, said that no, if you're a foreign investor in South Africa, you are bound by the redress and transformation imperatives of the South African government, and that means your property is kind of subject to the same legal safeguards or lack thereof of domestic South African investors. So I would say that if there is a group of people who should be concerned about the act, it would be agricultural owners, large foreign owners of property in South Africa. And then in the future, and I think I must say this because it is really a worry, it would be people who find themselves on the cold side of whatever happens to be the incumbent government. The reality is you don't find laws like this in healthy democracies. You simply don't. The standard of just compensation or market compensation is international best standard. That's what you'll find in countries that work and are healthy and are socially healthy. Laws like this you tend to see in countries that there's something a little bit iffy about their political systems. I don't think that the ANC is going to start expropriating property of DA supporters in South Africa anytime soon, but it comes down to this. This is the law of the land now, or it will be once it's proclaimed into practice, and you will see amendments introduced to this act over many years, decades, etc., and it might become worse. I think that this kind of opens the door to some very nasty abuse that at least people must be conscious of. But again, currently, if you own a house, if you own multiple houses, maybe you should be worried. But if you own a house, you can probably forget about this act and maybe just oppose it in principle and so on as a threat to our economy. But homeowners, even new title deed beneficiaries from, for instance, the Kaya project, I don't think are in a terrible amount of trouble. And if they are, specifically if they are, this is where they have access, for instance, to legal aid, and that's where I think pro bono lawyers would be very eager, very, very eager to get involved, which will not be available necessarily to wealthy landowners. So I would say about this specific aspect, not terribly much to be worried about.
And one of those pro bono lawyers could be Robert. So, Robert, the Act grants the Minister of Public Works authority to expropriate land on behalf of other organs of state. And I'll put it to the team here. I mean, what impact will that have on the expropriation process? And I think Martin alluded to it and its potential for abuse.
Well, if I may chip in here, Anil, the thing is, what must also bear in mind is what will this cost government in the long run if they were to start expropriating that compensation? And here we can look at what we had, this piece of paper called the Davis report in 2018, which SARS wanted about when they looked at making certain reform to revenue collection, that sort of thing. And in this report, the Davis report, it comments on the fact that as at March 2017, for the previous financial year, there were 105,977 dutiable transactions in the various deeds offices throughout South Africa. So let's call it 106,000 transactions that had registered for the previous 12 months, where government was able to obtain revenue because of transfer duty. Now, for those who don't know, transfer duty is pretty much a duty, or let's call it a tax that you pay when you're buying a property above a certain value. And at the moment, all properties in South Africa where there's which you sell for more than 1.1 million rand, if it's not a vatable transaction, you have to then pay transfer duty. And I think, let's face it, most 2-3 bedroom homes these days in South Africa are worth more than 1.1 million rand. And some of them are worth hundreds of millions of rands. Now, the question that we have to ask ourselves here, and if you're looking at farms, you're also looking at millions and millions of rands. How much money is government going to lose if they're going to take people's land away without compensation? And in the 2017 fiscus, the year before that, they collected 8.7 billion rand just out of transfer duty alone. Now, that's going back 8 years. Now, in today's terms, who knows how many billions of rands the government is getting through transfer duty. So I also think government is going to have to make its sums and ask itself, all right, if we're going to go again on a rampage here and take people's land away, how much money are we going to lose out of transfer duty? And let's face it, at the moment, you're probably looking at 15, 16 billion rand in revenue just out of transfer duty, just out of the transfers of properties that are not vatable. So that's also something which government will have to take into account. And I don't think that government can afford to lose billions of rands in revenue out of transfer duty. I somehow don't think so. At the moment, the government needs every penny that it can collect.
Well, we'll see now when we get the budget next week whether we get a VAT increase or not, and what the outcome is going to come over there, because that would be an indicator if in terms of how they manage money. So let's talk a little bit about how does Expropriation Act align with the original goals of land reform? Could it be seen as a backdoor method for large-scale land redistribution? I don't know who wants to have a crack at that. Martin,
we have kind of done.
We've dealt with it. I think we're going to go around.
I had a follow-up question just for Martin. He was talking about healthy democracies also not having these types of laws. I mean, I feel like South Africa is a special place, especially given the peaceful transition of power that took place in 1994, where two completely opposing sides with different ideologies could sit together around the table and come up with a universal set of laws that was in everybody's best interests. I think that was a legal, miraculous moment to have. And I think the world admires us for being able to achieve something so fair and so reasonable and so peaceful. But we come from a past of such prejudice, where there is such pain and frustration. And many people that may have found themselves in possession of valuable lands may have had that land unfairly taken away from other people. Of course, we've got other laws. I think we discussed that in our pre-seminar as well in terms of retribution. Maybe we can also discuss that now as well if Martin wants to pick up that point. But we're not, although we may be seen as a relatively healthy democracy in some ways, relatively speaking, we do suffer from a bit of post-traumatic stress, I think, from some of the social and racial injustices that took place. That have allowed an inequitable distribution of land. So I hate to talk about the past, everyone wants to focus on the future, but it is the elephant in the room that I think we do have to at least acknowledge. But we had all these laws from, I think, 1913 up until the end of apartheid, especially between the 1950s, 60s, up into the 80s, which resulted in about almost 90% of the land being put into possession of 10% of the population. It was almost like 7 or 13%. Well, let's just stick with those figures for now. So we can't just ignore the past. We have to try and come up with a fair and reasonable way to try and address that situation. I'd understand the lack of confidence in government because of fraud, because of corruption, because of improper execution, possibly and arguably a lack of good faith, possibly dishonesty, a lack of forthrightness, a lack of being held accountable, all those dysfunctions. Okay, it's not a perfect system. But if we had to hold equal, I think, hold aside all of those issues, what would the perfect remedy look like? What would the perfect set of expropriation laws look like to try and fulfill this constitutional mandate of just and equitable land reform in order to address those social and racial injustices? It's just an open question.
Okay.
Yeah, if I can, Neil,
please. Please go ahead. Yeah.
Just so the Constitution itself, I mean, the supreme law does have a backwards-looking perspective, and rightly so. As I alluded to earlier, you cannot claim to respect private property rights if you do not take into account how the property was acquired, etc. So that is there, and the Free Market Foundation, it's celebrating its 50th anniversary this year. So for those who can count back, that means we were founded in 1975. Certainly back then, opposing what Andreas Wassenaar of Sanlam at the time called the apartheid government's free way to communism. Now, it's very rare for people to accuse the apartheid government of being open to communism, but we were the ones saying that, listen, this is a government that does not respect private property rights. This is a government that engages willy-nilly in the deprivation of economic liberties, and that is wrong. So I think everyone engaged in the discourse, maybe not everyone, all the kind of good faith actors, and I would include AfriForum and the Solidarity Movement in that category of good faith actors, recognizes that there have been injustices as far as land is concerned in South Africa's history, and these must constitutionally be repaired, redressed. And the Constitution, to me at least, is very clear about how that is done. First and foremost, I think this is the easiest one. Insecure tenure must be secured. So if your property rights were unclear, the government has to secure them, and that is what Kaya Lam does. Kaya Lam goes into old townships on the periphery of South African cities and sees that there's a bunch of tenants living in houses when they should be owners. They've been living in these places for generations. That is insecure tenure that the Constitution requires us to secure. And that's one aspect. The second aspect, very kind of straightforward common law reivindicatio, is restitution. And this has been, I think, a remarkably good process since 1996, when the Restitution of Land Rights Act was adopted. A very simple process. If you have a reason to think that there is some property out there that is in fact yours, it has to belong to you because it was taken from your ancestors, then you go to court and you prove it. You must be able to prove it, of course, because the truth is not a self-evident thing that exists in the ether. So you must prove it. And I think the last time I checked, 2.1 million land claims have been processed, of which the vast majority of beneficiaries decide to be paid out. Why? Because We don't live in a romanticized Marxist agrarian situation where people want to farm. Most people want to live in cities and be prosperous kind of participants in a modern market economy. So most of those restitution claims are kind of settled financially. Then there is the kind of more ambiguous provision that is about equitable access to land, which is section 25.5 of the Constitution. Now, a lot of people have interpreted this as meaning the state must look at South Africa's land situation and see that, oh, that race group owns too much or that race group owns too little, and it must take property and mix and match kind of to achieve a more equitable distribution of land. I think that is a preposterous reading of a constitutional instrument because it elevates an academic concern, really. It's an academic concern to say, well, X population number percentage X must own X of whatever. Like I made this example during our dry run, is that in New York City, Korean Americans and Chinese Americans represent less than 1% of the New York City population, and yet they own more than 80% of nail salons in that city. Now, to me, that does not rise to the definition of a problem. That is not a problem that needs a solution. And that in isolation, the distribution of ownership is not a problem. And I do not think the Constitution sees it as a problem. The Constitution recognizes the injustices of the past, very specific acts of government tyranny that the apartheid government inflicted, which must be redressed when it's proven that property was taken. But in all other circumstances, if you come across a piece of property that is owned by someone, you must assume that that person owns it legitimately. You cannot, by looking at their race or whatever, assume that they own it illegitimately. There are white property owners in this country, agricultural owners, who purchased their property from black pre-owners. I mean, after 1994, there is a very healthy and vibrant property market in this country. And the government cannot, without further ado, say that, oh goodness, that big piece of North Cape property is a huge how many ever acre farm, and it's owned by a white guy. Therefore, 2% of the surface area of South Africa is not transformed, and now it must be expropriated, and worse yet, for no compensation. So that is not what I think the Constitution requires. The Constitution requires restitution. Very simple, very straightforward. It's been happening since 1996, and it's been happening at such a slow pace. Why? Because the government has invested a pittance, really, of budget in land reform. The portfolio of sports, arts, and culture, Gayton McKenzie's portfolio, has been receiving orders of magnitude more money. Sports, arts, and culture has been receiving orders of magnitude more money every year for many years than land reform in this country. And
Wow.
We apparently have a hunger for land. So it's not that the government has a reason that it cannot afford to kind of buy property and redistribute it kind of at fair market value. The act ultimately comes down to the government grabbing a power that I think many governments want, but understandably don't have, and that is the power to take property without paying anything. So yeah, just long story short, I agree. We have to look back. We have to understand that there were injustices, and we have to set them right. But there is a clear constitutional way to do that without destroying the very important constitutional institution of protected private property rights.
Okay, wonderful. Well said. I just want us to deal with the questions. We've got a barrage of questions here from the audience, and some we've dealt with a little bit, some we haven't dealt with. So I just want to pivot a little bit over here. But thank you for that, Martin. I think probably our Gayton McKenzie just a better minister, more efficient than the other ministers. That's why he's getting all the money, you know. So I think it's got to do with the quality of the team that's running it there and what they see as probably a top priority. But here's a question just related to what you were saying, Martin, from Sandy Powries, and I think we discussed it before. How will Jacob Zuma's fare with his land grab with the Hilton College in KZN? And I think you mentioned retribution. Do you want to maybe just your thoughts around that? Will he succeed? Can he succeed?
I'll just answer that very briefly. I don't want to hog the
Yes.
mic, but
No, sure. Yeah.
they have instituted a restitution claim. So that's what I mentioned earlier. They have to actually
Yes.
go to court and prove that
Yes.
some ancestor owned that property and it was taken from that ancestor in a kind of illegitimate way. And if they prove that, then they will have the choice to either get the land back or to take financial compensation. Now, this is obviously a very politicized use of the time we're currently in, and that must make us worry. But ultimately, for me, is if they can prove it, then they are right, and they must get that choice. I know it will be terrible for Hilton College, but they will then still be entitled to argue for full compensation, and then they can rebuild their historic college right next door if they want. If this happens without any compensation, then I think we need to start worrying quite a bit. But again, they have, MK's Zuma actually have to prove it according to the timeless principles of the law of evidence and due process.
Absolutely. So I want to deal with all our questions, and I'm going to ask each of you to briefly cover, because the time is just running away with us. I just cannot believe. But Peter van Zyl asks, the civil rights organization AfriForum has been warning all South Africans and lately the international media of the dangers of this new act. And of course, it's got as far as to America, Donald Trump, etc. And according to them, the act significantly jeopardizes private property rights. Is there any real grounds? And I think, Robert, I'm going to bring you in here, for the average South African who owns more than one property or even an investment portfolio to be concerned? Because you mentioned it earlier, don't be concerned. But does the new act empower the state to expropriate land or property in general without compensation, or is this just all politics?
Look, well, what the Act does say is, and in Section 12 specifically says that any land is subject to being expropriated without compensation. It does actually go as far as to say any land. So theoretically, I think we've all touched on this, that theoretically, I suppose the earth could also be struck by a meteorite in the next 5 seconds. Don't know. I'm just saying theoretically. But what the Act does say, and this is where there's a huge difference between the new Act now and the 1975 piece of legislation, because in the 1975 piece of legislation, the value of property was deemed to be the fair market value, full stop. It was about the only factor to be taken into account. What this Act says is the following. It says the current use of the property has to be taken into account. The history of acquisition and use of the property has to be taken into account. The market value has to be taken into account, the current market value. So that is a factor. Even if government wants to take away your land without compensation, they've got to look at the current value. So that is a factor which has to be taken into account. The extent of direct state investment, the purpose of the expropriation, and any other relevant circumstances. So we've got a lot more to look at now to determine whether it would be fair and equitable to take land away without compensation. In the past, government only had to look at the fair market value. Now we have to look at all of these factors. And here I want to cotton on what Martin and Simon have both said. You know, it would be grossly unfair if I, as a landowner, farmland owner, even if I owned a piece of land out in the sticks in the Midlands, where there's tribal claims to land and historic claims to land. If I've bought it bona fide, I've bought it from a third party 20 years ago, 30 years ago, or 10 years ago, I paid for it, I've been using it in a bona fide manner, I haven't stepped on anybody's toes, for government now to come along and take it away because maybe 200 years ago it was taken away from the rural or the previous or indigenous landowners. I can't imagine for a second that our government or any government could condone something like that. You'd have to compensate the person, because if not, it would be grossly unjust and unfair, and that would be highly unconstitutional. So unless one can prove that any current landowner took land away without compensation, just grabbed somebody's land, in any event, it's highly impossible, because since 1947, we've had the Deeds Registries Act, and every single piece of property in South Africa has to appear on a title deed or on a plan or something, has to be accounted for in a deeds office. There's no piece of land in South Africa which isn't accounted for. So I think it's fair to say that we have to assume that in today's economy, that every single piece of land which is owned or was acquired legitimately. I think, and again, I can't say that as a fact, but I would think that all land has been acquired legitimately. So how the land was acquired, well, how far back are we going to go? How many generations back are we going to go? And that, I think, can open up a massive can of worms. And like I say, if we're going to not take people's land away without compensating them when they paid for it, I don't see how any constitutional court could ever really justify that. If somebody paid for it, and if he acquired it under the bona fide belief this is a legitimate piece of land, a piece of land which was acquired legitimately, sold to me legitimately, I paid my dues, I paid my transfer duty, because again, if I've bought a piece of land which is worth 20, 30 million rand, your transfer duty, you're looking at millions of rands. So I've paid government, I've paid my tax to buy this property. Now I'm being expropriated without compensation. How can that possibly be fair? And again, what Simon also remarked on much earlier on is what is just, what is equitable? Well, those are legal concepts, and then if you looked at what we call the law of delict, to look at whether somebody was acting negligently, you always have to ask the question, how would the reasonable man have handled the situation at the time? What is the reasonable man test? Well, that is a concept that is as grey as what we're talking about today. When is it just? When is it equitable? Because what's equitable for me, what's fair and just for me, is not going to necessarily be what's fair and just for anybody here present today. It's a if I can call it a grey concept, which you can only really look at by looking at case law. You have to go back into other case law to see how did other judges handle similar circumstances, and that you have to then apply. And again, like I said earlier on, we're going to have to trust the institution. We're going to have to trust that our constitution, being held in high regard internationally, will continue to be held in high regard and will be applied with integrity by our constitutional court judges.
Okay, great. Thanks for that, Robert. Simon, and it's a question. I'm trying to get through all the questions. I'm also aware of the time. Question from Kerry. It's a double whammy here. Does this bill open the door to expropriation of other privately owned assets if the government decides it's in the public interest? 1. 2, and how does the expropriation bill align or not with the launch later this year of the Equitable Access to Land bill? And I also welcome Martin. I know do you want to add to that?
I think those questions are probably better served for Martin and Robert, but just very briefly. So there's this this Equitable Lands Access Bill that's been tabled. It's a mechanism to try and redistribute land in an equitable way to people in South Africa. It seems like the timing is more than coincidental after the Expropriation Act. It feels like the Expropriation Act is going to be used as a tool to achieve equitable land redistribution, whatever equitable means. The bill doesn't explain what equitable means. Robert did also mention something about a reasonable man test. I think the reasonable man test in South Africa is the person who believes in the values and the convictions of the Constitution. That is the reasonable person within South Africa. And not everybody is that. Not everybody, unfortunately, believes in equality and freedom of speech and human dignity and right to life and all these things. People have different ideologies. Okay, we have a diverse, multicultural society. But this document, the supreme law, this body of universally accepted and admired of human rights, is the documents from which is the litmus test for what is reasonable under the circumstances. So that should guide the courts in determining what is equitable. So this bill is controversial, I think, for some people. It's supposed to list a number of beneficiaries, identify certain beneficiaries who should be eligible for the redistribution of land in order to achieve the objects of that bill. It's also supposed to create a ceiling on property ownership, especially of agricultural lands. It's supposed to create a legal tribunal to try and resolve disputes. And it's supposed to also track various other things. I think I can leave it to Martin to talk about it. But Robert, you were shaking your head about the expropriation of other property, and I think perhaps you can answer that before I monopolize the time.
Thanks, Ali. I wanted to. I was very vigorously shaking my head because the Act very just to answer the question. The Act very clearly says that when it comes to addressing the wrongs of the past, only land is targeted, nothing else. Not your shares in companies or your SL 300 Goldwing that you bought on auction from a James Bond movie. Those assets are safe. It's only land that may be targeted in order to address the wrongs of the past. That's it, only land. Which again is one of the main concerns. Look, and I must also want to cotton on to what Simon said just now, that which types of land can be targeted. Again, any land is subject to this risk, any land. But Section 12 then does, odd enough, say it could be any land, including but not limited to, and then they've got those 4 categories. And 3 of those categories are all land which don't affect any of us whatsoever. One of those 3 being land that has been abandoned. Now, if land has been abandoned, well, it's got no value to me as the owner. I'm the owner, but I've abandoned it. I've given up. I haven't paid rates and taxes for 10 years. I've let the squatters take over and I've let them run it into the ground. Well, what value does it have to me? So why can't government take it away from me if I've let it go to ruin? So there's no harm to me at all. The only piece of land which I think could be of concern is the one which says that if you own land and you haven't done anything with it, and you're holding it purely for speculative purposes, that is the one piece of property which does fall under the properties where they say including but not limited to. Now, there I've got a bit of a problem with that one. There, I'm going to be honest now. I'm not worried about this legislation, except for that one little piece of or that one subsection, because if I choose to buy a piece of property in Camps Bay or Llandudno, and I want to hold on to it for 10 years because I know that in 10 years' time it's going to be worth 5 times what I paid for it. If I want to rather own that piece of property as against buying diamonds or gold or platinum or the SL gold ring I was talking about, why shouldn't I? I have the right to invest my money. I've got the right to choose how I want to make money going forward. That's also a constitutional right. It's called the right of freedom, the right of economic trade. Yet, oddly enough, they have singled that out. They have said, if you own a piece of land and you've been sitting on it for 5 or 10 years and done nothing with it, we're going to come for it. Yes, that is one piece of it.
It's like,
that is one.
It's almost, sorry to interrupt. It's almost as if government is forcing people to actively utilize their land to almost indirectly achieve the object of land reform. So forcing people to finish their developments, forcing people to lease out property, forcing people to enter into partnerships with the community members to create something on that property for some kind of communal or social purpose. So it does feel like we're being bullied into making use and enjoyment of our land in ways which aren't fully independent. And that's not, I think, within the dictates and requirements of true freedom.
Excellent. Okay, so we got a little bit of time. I want to deal with a few more questions, but I want to bring you in here, Martin. In particular, I've got a double-edged question, and it's obviously related to the whole international situation. From John, he says, expropriation and the future of South Africa property in the wake of the new US Trump administration has created havoc in South Africa. But does the rest of the world care? And how much could our property market be affected? And does our government care? Well, I think aligned to that, the legislation in the process still has to be approved. But do you believe that the pressure also from the US and other countries that this will change, or what is your expectation? So maybe just your comments around there, Martin.
Yeah, so I mean, I think my perspective on this might be a minority perspective here today, but I welcome the pressure, and the Free Market Foundation has welcomed the pressure, because we've been playing the public policy game for decades now, really, and there's been a lot of knocking on the door of government to tell them how important private property rights are, and that door has remained firmly shut. And only now that the international community is taking an interest, that door has now flown open, and now finally we're talking about the importance of private property rights. Now, it could go either way. It could go that the government digs in its heels, or behind the scenes, Donald Trump might be engaging in one of his famous deals. I'm definitely not one of the man's biggest fans around the world. I think he's a bull in a china shop, but it has made South Africa's kind of policy environment around race law and, of course, property law more fluid than it used to be. So there was a question earlier about AfriForum and solidarity, and I think to kind of just touch on that is that this is not happening in isolation. The South African government has had a remarkably anti-property rights posture from the start. So the apartheid government, we're well aware of how anti-property it was. But the democratic government in 1998 nationalized privately owned water in South Africa for example. In a few years later, in 2004, it nationalized minerals and petroleum resources. Its compensation was some form of leasehold and licenses and permits. Then I already mentioned the Protection of Investment Act, very much an attack on the kind of secure property of foreigners in South Africa. And now you have the Expropriation Act and the coming Equitable Access to Land Bill, which, I mean, none of this creates the impression of a government that cares about the strong protection of private property. I would add that it also doesn't create the impression of a government that cares about land reform for all the reasons I've already alluded to. This is a government that wants to control private property for ideological reasons. And I mean, those reasons are freely admitted by the ANC, freely admitted by the SACP, etc. So I think the AfriForum and Solidarity delegation to America is not a strictly legal concern with, well, this clause of the act like we are kind of engaging here today. It's far more of a political outreach to say, listen, world, President Trump, they're heading to Europe now. This government in South Africa is playing a long game, and that game tends to be against the private property interests of citizens, and private property is necessary for a flourishing economy. That's just something you cannot escape. So I think that the rest of the world will care to the extent that we can show them, or that other people can show them, that they have an interest in a stable and prosperous South Africa. They're not going to care in a vacuum. Realism and realpolitik, they won't care if we can't show them that tangible benefit. The government certainly, I don't think, cares. This is not the only economic malaise on the hands of this government. Unemployment is a huge crisis, and I promise you they do not care. They could have solved this problem a decade ago. They're not. So don't put your money on the government caring about solving this. Put your hope for, and perhaps potentially add to, pressure on this government, because this government responds to power, it responds to pressure, it does not respond to well-argued kind of letters and so on. And one of the pressures that's relevant for today is litigation. There will be a lot of litigation on this act. There will be a lot of litigation on various kind of other derivatives of land reform policy. So yeah, it's I welcome the pressure. I think it's finally brought about some level of fluidity to this government's posture on property rights, which really for 3 decades now has been very absent.
Is that pressure or treason?
Whichever way you put it. Okay, so
that's not my view.
Yes, no. So I think I can't believe it. We run out of time, gents. I mean, we still got more than 190 people still here. So they're obviously very interested on this whole topic. There's a bunch of questions, and what I'm going to do is actually send those questions through to you, and maybe we can respond to that, to some of those questions to them, and we can put it on our blog onto REI. But the way I would like to end is to probably get your final words, your final parting shots from the panelists. So if each one of you could, maybe give your minute or so, ending off your parting shots, your final thoughts, what people can do to take away, and maybe take away some of the fears in terms of the act, and maybe give people a way forward, give them something that they can work with. So starting with you, Robert, can you maybe give us your final words and parting shots in that context?
I'd like to cast my final spell here on 2 questions that I've noticed, if I can just address them, because I think
yes, of course, please do.
Where we're going with this is the one that Di Richard asks is, there are farms that have been given and have been completely run down and neglected. Can they be given back as nothing is happening on the land? In other words, where government has in the past expropriated land, dished it out to a community for to address the wrongs of the past, can that land be taken back? And yes, that is specifically one of the pieces of land which Section 12 does specifically target, which says that the government has already invested money in a property which is the same as or more than what the reasonable market value of the land is. In other words, where government has given a community an opportunity of addressing the past, and they've let the property go to ruin, then they can take it back without compensation. And there again, rightly so. The same as a property that's been abandoned. If you've abandoned it, or if you've run it into the ground, why should government not take it back and rather give it to somebody else to give them a shot at doing so? So to answer your question, yes, if government has tried in the past, then they can take it back. The other question that Stephen asks is, if there is a lease on the land, will expropriation without compensation apply? Because there's a Roman Dutch law about a lease being stronger than a sale. Well, the nice thing about this piece of legislation is it specifically says that anybody that has a right to or interest in the land has to be consulted as part of the negotiation process, which means a bank, which means a person that has a usufruct over the property, a person that has a lease over the property. If I stand to inherit the property from a deceased estate, if I stand to get the property from a divorce, I'm entitled to be consulted. I have a right I have a voice. So my closing point here, ladies and gentlemen, is that every single person that has any sort of interest in that property has a right to be heard, has a voice in the matter. So it's not a case where the expropriating authority is going to be able to simply say, they're going to spin the dial and see where this arrow points and say, right, we're going to try and take that property. If they do so, they have to go through a very long administrative process, because they have to start the consultation. And again, like I said just now, if they can't agree on an amount of compensation, once they've gone through this entire consultative process, they have to take it to court, not the landowner. Government has to take it to court. So again, at the end of the day, it's always going to fall back to the judicial process, always going to fall back to the hope that our courts will jealously protect our constitutional rights, as they have. That's been proven. That is cast in stone. Our courts have always very jealously guarded our constitutional rights. And I don't see that changing unless the president is going to fire all the judges out there and replace them with judges which will heed their call, which is highly, highly unlikely. I just don't see that happening. It's an absurd notion, I think, to even take into account. So that is my closing point, Neil. Thank you very much from my side.
No, wonderful. I think a great way to end there, Robert. It's on a positive note. The courts will protect you. And, we don't have a Zuma situation at the moment, and which possibly could have we steered the courts in a different direction. So thank you very much. That's Robert Krautkramer. He's Director, Attorney, Miltons, Matsemela. Great. Thank you very much. Simon, your closing parting shots, please.
Yeah, certainly. I think the Expropriation Act has some merits. I think the objects are theoretically sound. We're going to have to look at the integrity of its execution by politicians. That's going to be the greatest test. And we do live in a land of laws. We do live in a land where there is a hierarchy of courts. We do live in a land where there is a constitutional democracy and a separation of powers, where different branches of government or different institutions look after one another in terms of checking each other and balancing each other out. So let's have a look at how the government executes this act, if it even reaches that point. Let's see how the courts interpret what is the public interest, what is a public purpose, what is just, what is equitable, what is fair, what is rational, what is reasonable. Okay, all within the confines of the Constitution that was agreed to by opposing sides in 1994. We all know sections 25, everyone has the right to private property ownership, but there is a recognition for us to redress or rectify the dispossessions from the past that were done from an arguably immoral perspective.
Excellent. And that's Simon Dippenaar. He's the director, founder of Dippenaar, Associate Attorney of the High Court. Thank you very much for being with us today, Simon. And then last but not least, Martin van Staden, do you want to give us your final parting shots, your perspective? You got the last word, so you got a bit of sway here.
Thanks, Neil. I really appreciate the opportunity today. Very, very important work. I guess I would want to leave everyone watching just with what we at the FMF have been saying for decades now, and that is that the kind of route to prosperity has been charted, and it's been charted many times around the world. We know how to achieve the end of poverty. We know how to achieve the end of destitution. This is something that many countries have done, and they've given us the evidence. That is through a legal political dispensation that respects the liberty of the individual, that respects the private property of the individual, key aspect, that respects free enterprise, economic freedom, and that has a severely limited government according to the law and the Constitution. The Expropriation Act poses a threat to two of these at least, which is private property rights and limited government. This is an act that gives more power to the state. It does not really, in my view, curb the power that the state already has. So this is not, in our view, a good piece of legislation, and that we are heading down the wrong path trying this out. So what can people do? I agree with everything Robert and Simon have said. I would add that another thing that people should do, and this is more kind of speaking to the policy and political side of things, is identify the organizations that are standing up for your right to private property and give them a hand. It's not just the Free Market Foundation, but I would be remiss to say that we are not one of those. So if you can afford some spare change, please do donate to us. We are an NGO. We are entirely reliant on you, but we're not the only ones. There's also the business group Sakeliga. There is the Institute of Race Relations. There is Solidarity and AfriForum as well, controversial as though they might be. If you care about the protection of your private property rights, these are at least good friends to have, I would say. And civil society really is going to be at the forefront of litigating against the Expropriation Act and trying to do whatever we can to lessen the impact, the negative economic impact that this would have on property owners and especially on the poor ultimately. So please open your wallets if you can, and if you cannot, please provide moral support, write a letter to the editor, give us a like on social media, share the content. Please just get involved, because ultimately organization and involvement and activity are really the things that guarantee kind of success in any kind of policy or political enterprise. Passivity is not the answer, and one of the guarantors of being passive is to panic. So do not panic. Panic leads to inaction. This is not something to panic about. This is something to be worried about. Do not panic. Rather, get involved and let's fight this thing. And if we can't beat it here, we'll develop good jurisprudence on a case-by-case basis as this law starts developing in practice. So again, thank you, Neil. Thank you to REI.
Absolute pleasure.
It's been a great pleasure.
Wonderful. That's Martin van Staden. He's head of policy at Free Market Foundation. And I echo what he says. Please reach out to that organization. They're doing some magnificent stuff. Maybe, Martin, I mean, per title, what could somebody could contribute to somebody's title? What is it? I mean, we're not talking lots of money here. What is the title? I think it's about 5,000 Rand or something like that. Is it something? So if you want to make a real significant contribution, that's, am I right or wrong?
Let me, so go to kayalum.org.za. It's currently a title will cost you 3,750 Rand. And
wow.
That is a bargain. That's much less than what a conveyancer would ask you on the open market. And that puts a title deed in the hands of a deserving family that has lived on property without ownership, property that is really theirs. It's their property. We're not giving houses to people kind of rent seeking. This is someone's house that they do not have protected ownership for. And for just under 4,000 Rand, you can help protect their private property. So please, if you're so inclined, kayalum.org.za, and please follow the steps.
Great. And I got from your colleague, Gail, she confirmed the 3,750 per title. So, yes. So that's it. We've come to the end of the event. A huge thank you to Robert, Simon, and Martin for joining us today, sharing your invaluable insights on today. I think it was a fascinating discussion. And I think we've got to watch in which direction this thing goes. And I think we need to do a follow-up and how it progresses. So definitely, I think later on during the year, we definitely need to revisit, this particular act to see how does government respond? How does this thing move? What happens to the US and Trump and all the pressure that's happening internationally, which direction that goes? So your contributions as panelists have really enriched this session. So thank you very much. And our attendees, thank you for all your questions. It's been wonderful. I hope you've walked away with a wealth of knowledge. I really must congratulate this team. It's really, really wonderful. If you want to reach out to any of us, just come to info@rei.co.za or just go to the contact us page on the rei.co.za website. Just before we wrap up, I want to remind you of our next webinar. No webinar next week, as REI will be reporting from the Business Conference, and also our next webinar will be Wednesday, 19th of March, because Friday is a holiday. We're talking the role of, and that's Friday the 21st, the role of auctions in business rescue and asset disposal, unlocking property value in challenging times. So join us for a deep dive into auctions. And once again, a massive thank you to all of you who tuned in today. Your participation and questions were fantastic. This is what makes these weekly webinars so meaningful. It really does. And we hope that you leave today's session with actionable insight, but also with a new view on how you deal with your real estate and the market and the impact of this new act that it has. And we hope it takes you to great new heights. Please reach out to our panelists here. They've all asked. I mean, I heard some pro bono stuff. I don't know how close we are to that, but please use their services as well. So we don't want to do pro bono. People need to be paid. They need to be paid to do their work. So, we've got an eviction attorney over here. We've got a specialist attorney here in expropriation. So please reach out to them as well. Once again, I'll just say thank you to everybody. Finally, this is Neil Peterson of REI alongside our expert panelist team signing off. Until next time, we will see you then. Cheers, everybody.